you're going to do.
Lewis, you ready to go now? And we'll just put the other guy on last.
Sure.
Do that. Nick, are you ready to go now on the speedy trial issue?
Nick,
Ready, Judge.
All right. And we're on Zoom. Okay, at this time, we're taking up case number 636-836, State of Texas versus Gregory Corbin Marquardt, and a motion to dismiss for lack of speedy trial. Mr. Marquardt is represented by Mr. Luis Martinez. Mr. Martinez, would you please clarify for the court and the assistant criminal district attorneys the basis of your motion?
Okay, Judge. It's pretty simple, Judge. This is a case where the state dismissed on the verge of trial because the state wasn't ready, and then they later refiled it, and they're looking for a second bite at the apple. Judge, it's our contention that the case should be dismissed because Mr. Marquardt's been denied his right to a speedy trial. The proper remedy right now is not setting it for trial because the state already had that chance and it's already been set for trial before. The proper remedy at this point, because his rights have been violated, is a dismissal. So just by way of procedure, Judge, this case is pending under cause number 636-836. The offense date is June the 4th of 2018. And this case was filed it looks like in April of last year, April the 8th of 2020. Previously, Mr. Marquardt had been prosecuted under case number 601-250. Once again, for an offense on June the 4th of 2018. So this is the exact same case. Mr. Marquardt was not arrested at the time. There was an accident. He was taken to the hospital. He was not arrested. In November the 19th of 2018, the state filed the case, which they were perfectly within their rights to do. Mr. Marquardt found out that he had a warrant. He contacted me. We turned him in. He got out on bond, and his case was assigned to County Court 8 to Judge Roman. And that was in February of 2019. On his own volition, once he found out he was being looked for, he went ahead and turned himself in. We went over discovery. We went ahead and filed for or requested a jury trial August the 27th of 2019. And the case came up for trial less than 30 days later on September the 24th of 2019. At that point, it was dismissed for further investigation. We went ahead and checked on a warrant because we were told there was a possibility of a refile. So we went ahead and checked for a warrant until March of 2020 for 6 months. Mr. Marquardt contacted me. I would continue to call the DA's office, continue to call the sheriff's office. We didn't find a warrant. So after 6 months of looking into the case, we went ahead and stopped looking at it because, at some point you just stop looking. A month later, in April of 2020, the case was filed, and then he was picked up on a warrant in February of 2021 for the same case, and that's what's got us here today. So, Judge, I do have Mr. Marquardt here to present and to prove up the prima facie case for lack of speedy trial. So I'd like to present him as a witness.
Let's hold short just a second. Mr. Moreno's here. Mr. Moreno, can you hear me, sir?
Yes, sir.
Hey, thanks for joining us. I know you had to jump through some hoops to get that done. I'm going to go ahead and take this plea real quick on Mr. Moreno and get him out of here. So it's a miracle we got him in the first place.
That sounds good, Judge. I understand.
All right. And I don't see Mr. Moreno anymore on my, oh, there he is. Sure we are. Okay. This is cause number 645-141, State of Texas versus Richard Anthony Moreno. Mr. Moreno, I'm looking at a document entitled Defendant's Consent to Plea by Video Conference, which is allegedly signed both by you and your attorney, Mr. Darling. Is this your signature on this document, sir? And you have to turn your microphone on again when you want to talk to us, sir.
Yes, sir.
Thank you. And Mr. Darling, as attorney for Mr. Moreno, is this your signature on this document, sir?
It is, Your Honor.
Next document I have, Mr. Moreno, is entitled Defendant's Waiver of Constitutional Rights and Court's Admonition, that purports to have your signature on the back, effectively waiving certain constitutional rights you must waive in order to enter a plea before this court. Is this your signature on this document also, sir?
Yes, sir.
By signing this document, are you telling me that you had enough time to either read this document or have it read to you in its entirety. If you had any questions about what was on this document, those questions were answered to your satisfaction by your attorney, so that in signing this document, you're telling me that you agree with and understand everything on this document. Is that correct, sir?
Yes, sir.
Mr. Garland, as attorney for Mr. Moreno, have you had enough time to go over this case with him? And in your opinion, is he mentally competent?
Yes, as to both questions, Judge.
Mr. Moreno, are you a United States citizen, sir?
Yes, sir.
And Mr. Darling, has the state fully complied with discovery for you on this case?
Yes, sir.
Mr. Moreno, to the charge of evading detention, how do you plead, sir?
Guilty.
You're in agreement for Mr. Moreno, and I believe your paperwork says no contest. Mr. Darling, which would you rather have us accept?
Well, no contest, please.
Court accepts plea of no contest to the offense of evading detention. State, is there an agreement?
7 days in the Bexar County Jail, $200 fine plus court costs, credit for time served, time and money to run concurrent, and the office to be a JSAT.
And Mr. Darling, is that your understanding of the agreement?
Yes, Your Honor.
Mr. Moreno, on cause 645-141, the court accepts your plea of no contest to the offense of evading detention. I find you guilty. I assess 7 days in the Bexar County Jail, a $200 fine plus court cost, credit for time served, time and money to run concurrent, judgment satisfied. Anything further from the state or the defense on Mr. Moreno?
No, sir.
I'd like Mr. Moreno. Thank you, Mr. Darling. Y'all are
Thank you.
okay. Back on the record on cause 636-836, State of Texas versus Gregory Corbin Marquardt. And I apologize for interrupting, Mr. Martinez. Go ahead. I've got some key dates down, and I'm going to go over them with you when you're finished setting out your presentation, and make sure everybody's on the same sheet of music. Go ahead.
Okay. So, Judge, that's just procedurally how we've gotten here. So what I need to do at this point is present Mr. Marquardt to prove up the prima facie case. Once again, I'm offering him simply for the limited purposes of this hearing. So I'd ask the court swear him in so I can start asking him questions.
Just to prove up your dates, or what specifically are you trying to prove up?
Well, I mean, once again, Judge, we've got the Barker factor, so we have to go and kind of prove those things up, and I can present evidence and all that.
Okay. Mr. Marquardt, please raise your right hand, sir. Do you swear the testimony you're about to give to be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Mr. Martinez, you're witness.
Okay. So, Mr. Marquardt, one of the first things that we have to show under kind of the case law here is that there's been more than 8 months of delay. So, is it true that is your understanding that you were charged with this case November the 19th of 2018?
Yes.
That's when the warrant was issued originally for the first case.
Yes.
Okay. Did you ask, or, let me back that up. Once again, how did you find out about this case?
The first time?
Yes, the first time.
Was through you, I
Okay.
believe.
And then you had gotten a postcard as well, right?
Yes.
That informed you had a warrant.
Yeah.
Okay. And then so once that happened, what did you do?
Went to you and we turned myself in.
Okay. Do you remember about how long was that? Like a month before you turned yourself in, or closer to a week or a few days? Do you remember?
It was within that week.
Okay. So within that week, you went ahead and turned yourself in,
Yes.
and we got you out on bond.
Mm-hmm.
Okay. So, you remember that your case went to Judge Ramon's court. You remember Judge Ramon?
Kind of, yes.
The older Latina?
Yes, yeah.
Okay. So we were in her court for a while. We discussed your case. We went over your reports, right?
Mm-hmm.
And then is it true that in August the 27th of 2019, we set your case for trial?
Yes.
Okay. And what happened with that?
I believe it was dismissed.
Okay. So has it been more than 8 months since you were initially charged with this case?
Most definitely.
Okay. Has it been more than 8 months since you asked for a trial in this case?
Yes.
So no matter what date we're going off of, it's been more than 8 months.
Correct.
Okay. So the next thing I need to ask you for is why there's been such a delay. Once again, when you learned of the charges, or initially in this case, the first time, You turned yourself in, right?
Yes.
So you didn't go on the run for a year or 2 years or 3 years.
No. No.
Um, and you showed up for trial in September of 2019.
Yes.
You were there in court 8.
Mm-hmm.
And what happened in September of 19?
I believe it was dismissed.
Okay, I let you know the case is being dismissed.
Yeah.
Okay, was it? Um, and it was your understanding at that time that the state was not ready for a trial, and that's why the case was dismissed.
Yes.
Okay. After that happened, you and I had discussed the possibility this case could be recharged, right?
Correct.
Okay, and so were you concerned about that?
Yes. That's why. I had you look to
Okay.
see if there were going to be any more warrants.
And you and I got with each other about every 30 days to look for warrants.
About once a month.
Okay.
For 6 months.
Right. And so after about 6 months, you and I stopped checking for a warrant.
Yes.
How was it that you became aware of the second of being recharged with this case?
I was pulled over for a traffic stop in Hill Country Village,
Okay.
and that's when I found out that I had a warrant.
Had you received a postcard like the first time?
I did not.
Had you received a postcard telling you that the case had been refiled, what would you have done?
Gone straight to you to hopefully solve the issue and turn myself in.
Turn yourself in again.
Yeah, again.
So one of the other things that we have to show the court to complain for about that your rights have been violated is that you in fact asked for a trial.
I did.
Okay. So did you ask for, let's see, in November of 18, when you were initially charged with this case, did you ask for a trial right then and there?
I believe so, yes.
I'm asking you, when they issued the warrant the first time,
No.
were you aware that the case was even out there?
No, I was not.
So you were not in a position to ask for a trial.
No, I was
Okay.
not.
But after you had turned yourself in and we looked at your case, we did spend some time kind of looking for evidence and putting your case together, right?
Yes.
Okay. Now, when the charge happened, let's let me back up. You were in a traffic accident, right?
Yes.
And you were located within your vehicle.
I was.
And once again, this was in June of 2018. You were not arrested, right?
I was not.
You were not charged with the DWI at that time.
I was not.
And what did you do with that particular vehicle?
Well, I totaled the vehicle, and when I got out of the hospital, I got rid of the truck at the salvage yard to pay for the fee at the impound.
Okay. And so if there were any evidence of that case, if that car was going to be, the truck was going to be useful for evidentiary purposes, you lost the truck at that point, right?
Yes.
Okay. And had you known that you were charged with the DWI, would you have held on to that vehicle?
I would have.
Okay. In fact, there's some damage to the inside of the windshield.
Mm-hmm.
Okay, consistent with someone hitting their head, and
Yes.
that's on the passenger side, right?
It is.
And you do have a photo of that.
We do have a picture of it.
Okay. And you were the only person that was found in that vehicle, right?
I was.
Okay. And so you don't know how it came to be that that your head hit the passenger side of the vehicle.
Mm-hmm.
And you don't remember the circumstances of the crash
I do not.
because you had a head injury.
I've had probably the worst concussion. My family, well, it was bad.
And so our ability to look to see if someone else had been driving the vehicle, that was compromised by the fact that you sold the car for scrap.
Yes.
Okay. So after we looked at our case and tried to figure out where our defenses were, we went ahead and set the case for trial, right?
Correct.
And to the best of your knowledge, that was in August of 2019.
Yes.
Okay.
I don't believe so.
Okay, so at that point, we affirmatively told the court we want a trial in this case.
Yes,
And in fact, we got a trial setting within 30 days at that point.
I believe we did.
So, okay, so one of the things I have to show is that you invoked your right to a trial. In fact, it's on the record that you did that.
Yes.
So the next thing that I need to show the court is that you have been harmed by this delay.
Okay.
So the first delay was when the accident happens in June and you're not charged until November, right?
Mhm.
And then you don't find out about it till February.
Yes,
And that delay cost you evidence in this case.
it did.
Okay, so it made it harder for you to defend yourself. Is that right?
Correct.
So you were harmed in that way.
I would say so. Yes.
Because had you known you were being charged with a DWI, you would have held onto the truck.
100%. Yes.
Okay, and the other delay, the delay between September of 2019 and February of 2020, when you, I'm sorry, 2021, when you're arrested.
Yes.
What harm or what prejudice, what harm did you undergo because of that?
Well, being arrested for a minor traffic stop, the 23 hours I spent in the county jail.
Okay, so let me back it up. Unlike the first time, you didn't get a postcard the second time.
No, I did not get a postcard the second time.
Okay. And we had stopped looking for a warrant because we looked for 6 months, and at some point we just stopped looking.
Correct.
Okay. So you were caught completely off guard.
Yes.
Okay. You had to spend essentially almost 24 hours in jail.
Correct.
Okay. I was informed of that. I went and got you out, but
Yes.
you still had to go down to the magistrate's office and over at the Bexar County Jail and go in there.
Yes.
Okay. In addition to that, am I handling the second case for free?
No.
So you're having to pay an attorney for a second charge because the first charge was dismissed.
Yes.
So the state's delays in this case has cost you evidence, right?
Correct.
It has cost you a day of your life,
Correct.
and it has cost you an additional attorney's fee.
Correct.
Okay. And those things would not have been done had you been given a trial the first time.
Correct.
I'll pass the witness.
State, cross-examination.
How you doing today, sir?
He's talking to you.
Oh, how's it going?
Good. All righty. So I just have a few questions. So this accident, sorry, this is the first time I've heard about this accident and things happening. So I hope you're all right from all that. The accident that you had, was your truck totaled?
Yes, it was.
It was. And because it was totaled, you decided to just give it up for scrap, correct? So that you could get the money for it and pay your impound fees, correct?
Yeah. So, yes.
Okay. And I guess my question is that the reason the car was lost was because you got into a traffic accident, correct?
Yes.
Okay. So really, but for that accident, we would still have the truck, correct?
Yes.
Okay. Additionally, he was asking you about how you hit your head, how you could have possibly hit your head on the passenger side of the vehicle.
Yes, the windshield was shattered, like someone's face went into it.
Did you have a seatbelt on?
I did not.
So it's possible that, I mean, because from the picture that I saw, Judge, I'm not sure if you've seen the picture, Mr. Martinez provided me with it. It's possible that from the force that you hit that tree with the truck, because you did not have a seatbelt on, that your body could have been flown into that area of the car.
I don't know.
You don't know.
I do not know.
Okay. So I guess the crux of what's happening here is you think it's possible someone else could have been in the vehicle.
Very possibly.
And we're basing that on the fact that there is what looks like an impact of where a head could have hit the vehicle on the passenger side where the windshield is.
Yes.
Okay. But you did not have a seatbelt on.
I did not.
Okay. No further questions, Judge.
Anything further, Mr. Martinez?
No, Judge, I have no other witnesses.
Judge, I would like to just address some of the things. I couldn't do it during cross, but address some of the things that Mr. Martinez talked about in the beginning.
Lewis, do you have anything else to represent at this time? I'm going to go over the dates with you here in a minute and make sure I'm on top of those.
No, Judge, I don't have any other witnesses. I've got no other evidence to supply to the court. It's my motion, so I will retain the right to close.
Go ahead, Mr. Murray.
Judge, just to address defense counsel's what seems to be the main argument here, that the case was dismissed and refiled and that it caused such a long length of delay. It's been set out that the delay before the charging instrument is filed, isn't really taken. It isn't really looked at by the court. That's why we have statute of limitations for a 2-year period to protect us from, so we can dismiss and refile pending further investigation for a missing witness, things of that nature. Once this has been alleged, though, it is up to defense to show, it is their burden to show that there is some type of bad faith effort or that the state was trying to attempt some tactical advantage in doing this. From what I've heard so far, I haven't heard anything alleged from defense that that's what the state was intending to do. I will not deny that the case was filed and then dismissed and then refiled, but the case law has set out that that is on the defense's burden to prove that it was a bad faith effort on behalf of the state. Additionally, Judge, I would just like to address when Barker laid out the prejudice factors. I'm not going to dispute the length of the delay because I can't. Time is what time is. But I will say that the main factor Barker looked at was prejudice. And in this case, according to defense, he did not know that there was another case pending against him. So he couldn't have had emotional distress. He said he did know that his attorney told him the possibility it could be refiled, but not that there was a pending case and there was any emotional distress. For pretrial incarceration, I'm sure the court was talking about more than spending 1 day in jail when they were talking about a type of prejudice that a defendant could incur from a delay. Additionally, any type of impaired defense, as I said before, it doesn't sound like it was through the DA's office or the state in any way that we lost that truck. I mean, according to the questioning that the line of questioning that just occurred, but for the accident, we would still have that vehicle. So that, I mean, that's not really on the state's fault at this point. Additionally, I spoke about the seatbelt and how that could have played a factor. Lastly, the fact that paying his attorney would cause him some type of emotional distress or some type of prejudice. Judge, nowhere in Barker did they lay out paying your attorney as something that could be caused as a prejudice towards the defendant. If that is in there, I would like to be shown that so I can not make this argument. Nothing further.
Okay. Mr. Martinez, if you would, go over these dates with me specifically, make sure I'm on the same sheet of music. The original offense date was June 4th, 2018. Is that correct?
Correct.
And what date was the original information filed in clause 601250?
So the original information was filed on or about November the 19th, 2018. Well, that's when
Of 2018?
yes, it looks like maybe 11/16 of 2018. The warrant was issued 11/19.
State, is there a reason from your perspective why the state would wait so long to file?
Judge. Well, are we talking about the original one that was in 8?
We'll call them the county court 8 case and then the county court 6.
Okay, that'll help me out.
Case, the original case, and I believe Mr. Martinez said its original cause number was 601250.
That's correct, Judge.
Okay. The offense date where the defendant was arrested, best I can tell, is June 4th, 2018, but the state didn't file the information until November 19th, 2018. Does that sound right, Lewis?
No, Judge.
Okay, when was the information filed on the original case?
It looks like on or about the middle of November 2018. So about
2018.
5 months later.
All right, so let's talk about 5 months later. State, why does it take 5 months to to file an information on a DWI case? I guess is my question.
Judge, sometimes we do not get everything that we need to charge the case. Sometimes additional body cam needs to be requested before we can look at it and ethically charge a person with an offense. Also, I'm not sure, I don't have it in front of me. I don't know if this was a blood case or not. Louis, do you know about that?
I believe it was a blood case, and it was a case where he was not arrested at the time, so he didn't bond out on, in June of 2018. The case was
Not arrested on 6/4/18.
correct. It was a direct file case.
What day was he actually arrested in? That's a good question.
Okay, so he was arrested on that warrant. He turned himself in on that warrant in February the 6th of 2019.
So he actually went to jail for the first time in this whole series of incidents on February 6th, 2019. Does that sound right?
Correct.
Correct, Judge.
Approximately 24 hours in jail that time. Is that correct?
Well, no, that's when we went ahead and we were aware of the warrant because he got a postcard. He comes to me and says, "I got this postcard. It's okay. Well, there's a warrant. Let's go turn you in." So we go and turn him in, and so he doesn't go into anything more than the satellite office at that point, Judge.
So like a walkthrough booking kind of thing. That basically what y'all did. I got you. And that was February 6th, 2019. What was the actual trial date when you showed up ready for trial in County Court 8 and the state announced not ready and dismissed the case in your face?
Well, let's talk about one date before that. So August the 27th of 2019, Judge, we went ahead and asked for a trial. We requested a trial setting. So we get a trial setting September the 24th of 2019, and that's when we show up ready and the state announces not ready and dismisses the case for further investigation.
And I guess, obviously, Nick, you weren't involved in this. You don't have any reason why the state was not ready at that time?
Judge, all I can see is that looks like some discovery was ordered, and the standing discovery order was signed by Judge Saldana February 28th, 2019. Perhaps they were waiting on that, but I can't speak, Judge. I wasn't even a licensed attorney at that time yet.
Okay. So the case was dismissed by the state on September 24th, 2019. What date did they refile it under a new cause number, Louis?
So it gets refiled under the new cause number.
I believe April 4th, 2020, or April 8th, 2020, correct?
Yeah, that's when the warrants issued. So right around that time. So beginning of April of 2020.
Okay, and this was also filed at large, apparently. Does that sound right?
Correct,
Correct.
Judge.
Did Mr. Marquardt have to make any court appearances on the original case? I mean, obviously, you showed up for trial that day. That's one. Did you go to, was that two? How many different times did you have to go to court on the first one?
Well, I mean, Judge Ramond is not big on people not being in court. So we would have been in court. It looks like end of February. So February 28th, 2019. April the 30th, 2019. June the 18th of 2019. And then August the 27th of 2019 when we set it for trial. And then he showed up September the 24th of 2019 when it was dismissed.
And it was refiled with a new cause number on April 8th, 20, and then assigned to County Court 6. That sound right?
Correct. So 7 months later, it gets refiled and assigned to this court.
Okay, so, and it said some point after April the 8th, 20, did you also once again set it for a jury trial?
Judge, we've not asked for a jury trial because at this point, once his right is violated, there's no undoing that violation. So if his right was violated, then the remedy at this point is a dismissal.
So you did not request another jury trial?
No, because we weren't aware of it until February of this year when he got picked up randomly.
Give me that date. The second case, the new case, was refiled under a new cause number assigned to County Court 6 on April 8th, 20. Is that correct?
Correct.
What date was he actually arrested, or y'all turn yourself in on this one?
He was arrested February the 4th of 2021. So we checked for that warrant for 6 months, didn't find it. And then in month 7, it was filed. And then it was out there, no notification. And he gets picked up on a traffic stop in February of 2021.
February the 4th of 2021, he was arrested for the second.
Correct, Judge.
Okay, got it. Okay. What other critical dates other than those do I need to be looking at?
I believe that's it, Judge. That's all I've got highlighted in my notes.
Motion according to on March the 9th, 2021, correct?
Correct, Judge. Yeah, I did confer with Nick on the case, confirmed that it was the refile, and then talked to him a little bit about it, and then I went in and filed the motion.
State, are you ready to try this case today, so to speak, quote unquote?
Judge, if we could go today, I mean, I would have to get my officers and let them know what's happening, but
The state is announcing ready, so to speak, today. Obviously, we're not having a trial today, but like
Well,
30 days today, you could be ready for trial. Is that correct?
correct, Judge.
Well, Judge, today's not the day. It was September of 2019 they needed to be ready. If they weren't ready at that point, then we've got a violation.
Well, my recollection of having practiced law in Bexar County, San Antonio, Texas for 42 years is in most courts, well, actually, if the state announces not ready and dismisses the case in the face of the defense, some courts hold their feet to the fire and basically consider them in trial and attach jeopardy to the dismissal. Some courts do that. I don't know what Judge Ramon's policy was. Otherwise, the state has to have an absolute right to dismiss the case at any time for any realistic reason. And
Well,
yes, and they still file within statute of limitations, I guess. The statute of limitations start running on 6/4/18, and the second information was filed 4/8/20.
so 22 months later. And Judge, they can refile it. That's not the issue. The issue is that's not the issue at all. They have within the statute of limitations to do that. The issue was there a violation of his right to a speedy trial at that point? Because Judge, when the state files their information, what they're telling the court is we're ready to go. You know, you can arrest somebody for a charge and you can wait a year and a half and file it if you want, because you're still within the statute of limitations. But once you file that charging instrument, the counter starts running on their speedy trial rights, because the DA's office gets to determine when they file the case. And they don't have to file it a day before they're ready unless the statute of limitations comes around. So once they file that initial charging instrument in November of 2018, what they're telling the court is we're ready to go. Obviously, sometimes it doesn't work out that way. And had Judge Ramon given them a not ready in September, you know, that was her call, but she didn't. The state dismissed the case. We had asked for a trial, and the analysis, Judge, isn't whether they're ready to try the case now. The analysis was, did they give him his trial within 8 months after he asked for that trial? And if not, then why? Is it, and I strongly disagree with Mr. Maru in that the idea that we have to show bad faith in the state, on the part of the state. In fact, there's case law that says even court delays count against the state.
All right. So everybody agree with me that there was approximately a 5-month delay between the original offense date of 6/4/18 and when the information was filed on the first case, 11/19/18. That's plus or minus 5 months. That sound right?
That's correct, Judge.
And the second time, after the case was dismissed in Judge Ramon's court, it took the state 6 months to refile the second case. Does that sound right?
I think it's 7, Judge, September to
The first case was 9/24/19, correct?
Uh-huh.
The second case was filed 4/8/20.
Correct, Judge.
Right.
So October, November, December, January, February, March, April. 7 months. All right.
Lewis, do you remember the prosecutor you were conferring with in 8 at the time?
I don't.
Okay. Because I do have notes in here saying that, because it's funny because you said 8/27/2019, and I have a note in 8/26/19 saying that he will take a not ready tomorrow. So, I mean, I don't know if he actually took it or not.
I don't know.
That is in the file.
Yeah. I don't remember it. I don't remember. All I'm going off of what's on the D page, essentially.
Okay.
So it's been in County Court 6 apparently since the second case, since February 4th, 2021.
Correct.
And the plague basically hit us a month later. Would you agree, plus or minus March 20?
No. He's been in County Court 6 since February of this year, Judge, for 90 days.
February of 21.
Yes.
Okay, I got you.
So
Okay, all right, length of delay is plenty long. Reasons for the delay are unclear from the state. It's not certainly not Mr. Maru's fault. Assertion of the right of speedy trial was timely made. Prejudice to the defendant, I think, is the key issue on this one. Do you agree, Mr. Maru?
I agree, Judge.
And Mr. Martinez, do you agree?
Well, Judge, I think it's part of the reason. I mean, it's a balancing factor. Remember, it's not, you don't have to show all four factors. You have to show that the factors you have outweigh the ones you don't, if you don't have all four. So prejudice is important. And I think that we've shown that he's prejudiced by the first delay by not keeping the vehicle when there was some very real evidentiary factors and value to it. And then, when we talk about emotional distress, I think going to jail when you didn't think his case is coming back is a pretty good emotional distress. I don't want to go to jail for 24 hours. And, the fact that he had to hire an attorney twice is because of the state's delay. And I can, as the court's aware, I do not come at a discounted rate.
Judge, if I can address that real quick. As I said before, the truck was not lost as a result of the state's doing. I mean, there was an accident and it was totaled, and he got rid of it to be able to pay the impound fees. So that's no fault of the state. Additionally, spending 1 day in jail. I mean, they already said they discussed the fact that the case could be refiled. So he knew that there was a possibility that it could happen again because they discussed it.
Well, and Judge, this is my closing. This is once again, it's my motion, it's my closing.
Oh, I didn't know this was your closing. I thought because it was just a back and forth between you and Judge going. So I didn't know that was
either side said it's okay. Lewis, you want to go ahead?
Well,
Go ahead, stab the state in the heart like you normally do. Go ahead.
okay. Well, I mean, the fact of the matter is, Judge, it's, the second delay does, it's because the state wasn't ready, because he wasn't afforded his right to a speedy trial. Mr. Marquardt had to go back to jail. We looked for this case for 6 months. At what point do you stop looking? I mean, he knew there was a possibility. He's been diligent. He gets a postcard in the mail in 2019. He calls me. We turn him in. We would have done the same thing this time. So he's got to go and spend a day in jail, which obviously none of us want to do. We mentioned the idea. Mr. Darling mentioned he was too pretty. I'm also too pretty to go to jail, so we're not going to go there. And once again, there's a monetary prejudice, a monetary harm that Mr. Marquardt has encountered by having to hire me for a second time on this case. And once again, those things would not have happened if the state had not announced not ready, dismissed the case, and then waited such a long time to refile it.
State, I'll be happy to listen to what you have to say, but I'm focusing on the time it took between the actual date of the accident and the state filing is what, 5 months the first time, and then after the state had already filed the first one and dismissed it, refiling the second one took another 7 months. Have you got any explanation for why it takes the state so long to do that, especially the second time?
Hey, Judge, I cannot speak to any of that, and I'm happy to say that I mean, I wasn't here at the time, so I can't honestly say what was going on. Additionally, it was in another court, so I can't speak to the actual length of delay. All I can speak to is the prejudice at this point, and how it's not really material. But that's
anybody got anything else to say? Last chance, state.
No, Judge.
Last chance, Ms. Martinez.
Judge, it's easy. This is why the state should be ready. If you have to refile it, they're behind the 8 ball. They've got to show there was a really good reason why it was refiled, and they don't have that.
Okay, cause number 636836, State of Texas versus Gregory Corbin Marquardt. Defense motion to dismiss for lack of speedy trial is granted. Anything further from the state or the defense on Mr. Marquardt?
No, Judge.
Okay, good luck, Mr. Marquardt. Thank you, Mr.
Thank you, Judge.
State, good job. It was out of your hands.
Judge, are we excused?
Yeah, you bet.
Thank you.